Do we all have a good understanding of collateral consequences? We mean collateral because it's not direct consequence. Let's keep in mind this great quotation. You always hear people quoting movies, and I like to quote judges. Grab hold of this, if you will. If the right to counsel guaranteed by the Constitution is to serve its purpose, defendants cannot be left to the mercies of incompetent counsel. So what I want to talk about this morning is the law of direct consequences of a criminal conviction. I want to talk about the law as it applies to collateral consequences in the Padilla decision and how that affects what we do every day. But I want to talk also about how the Padilla decision shouldn't affect us at all if we're competent counselors. Judge Toll insulted all the criminal defense bar back in 1997 in a case Smith versus State. And Smith versus State was about a poor fellow who had burglarized a number of different commercial establishments, and he was pleading guilty to a burglary second charge. And he got his time, and what he wasn't told by his attorney is that the nature of the offense under the Criminal Reform Act back in 96 was that it was classified as a violent crime. Now, those of you who don't practice criminal law, you might find it interesting that our legislature has seen fit to classify what we would normally say nonviolent crimes as violent, and violent crimes, such as assault and battery of a high and aggravated nature, as nonviolent. It doesn't make a whole lot of sense, but what it does is changes the status of confinement. If you're convicted of a violent offense, you're not eligible for PTI. Your status of confinement within the Department of Corrections, you're not eligible for certain programs that they have. So it does have meaning to the client. It just doesn't have meaning in terms of length of stay. Well, Judge Toll, as every chief judge practically in the United States in the various jurisdictions, as they did in the federal jurisdiction, said, it's not up to the lawyer to advise a client of what is not a direct consequence. A direct consequence is pretty easy to figure out. A direct consequence, if we could move on, is what happens when you're convicted. And that is you're taken to the public square, you're hung, or whatever happens. The gray area is, if you leave that up, please. The gray area is, as you can see, the collateral or social consequences. All right? The public hanging is obvious. It's a direct consequence. What about the social stigmas? What about the other collateral consequences? Direct consequences would typically have been chain gang, work programs, penitentiary punishments, obviously being incarcerated. It reminds me of the old CCI down in Gist Street. But back in the 80s, maybe in the 70s, and turning into the 80s, legislatures around the country, including the Congress of the United States and the State House here in Columbia, started saying, you know, somebody going to jail for 10 years just isn't enough. We have to make the penalties stronger. We have to stand up for the citizens of this state and really punish people in different ways. All right, so there's public pressure now, there's social pressure, societal pressure to make punishments more universal. Not just jail, not just fine, but take away driver's license, take away school opportunities, take away housing opportunities. The traditional put somebody in jail started to become the smaller portion of the punishment. Convictions resulted in employment discrimination, housing discrimination, social discrimination, in many, many ways that are difficult to define. What we would expect you to do as representing a client is to understand the background of what the client does. How will a criminal conviction affect a client? You don't just start with and stop with 0 to 10 years. You look at, oh, it's a felony. Well, it's a felony. How is that going to affect his ability to earn a living? Is he going to be able to keep, or her, or are they going to be able to keep a business license? Are they going to be able to borrow money from a bank to build a home? Are they going to be able to live in a certain community? And what do I mean by that? Sex offender registry. Has anybody looked at the sex offender registry to see the limitations it puts on your client's ability to live anywhere they want to live, to work where they want to live, to play where they want to play, to go and be with whom they want to be? A great tension has then built up in the law as the result of all these extraordinary collateral consequences in the court system between the direct consequence and the collateral consequence. Justice Toll, as so many justices around the country, says there's no obligation, legal obligation, under the Sixth Amendment, the right to counsel. There's no constitutional mandate to tell your client anything about collateral consequences. In fact, in State versus Smith, the court went so far to say, it's basically, if they don't ask, don't tell. So if a client doesn't ask you what the collateral consequence is, you keep your mouth shut. What an insult that is to you and to me as an attorney. The issue behind this really is not in Judge Toll's court. You'll find it in the rules of professional responsibility. We have an ethical obligation to properly inform our clients. The preamble to 407 provide a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. What does that mean? Does that mean that the practical implication is, well, you may face 10 years in the penitentiary or a $5,000 fine? No, I suggest to you that it means far more than that. Your individual client, the individual problem he has, how is he going to be affected in all facets of his life? In all professional functions, a lawyer should be competent, prompt, and diligent. What does competent mean? Remember what Justice Byron White said. Competent means, as a criminal defense lawyer, that you know how a guilty plea or a criminal conviction is going to affect your client in every aspect of their life, not just in terms of a fine or imprisonment. In representing a client, a lawyer shall exercise independent professional judgment. They refer not only to law, but to other considerations, not just law, such as moral, economic, social, and political factors that may be relevant to the client's situation. There's nothing new about this. This whole Padilla hysteria from 2010 about advising the client of collateral consequences is an obligation we have always had. Look at the ABA standards. To the extent possible, defense counsel should determine to advise the defendant sufficiently in advance of the entry of any plea as to the possible collateral consequences. How much more direct can you be about what your ethical obligation is? How about the National Legal Aid Defenders Standards? When talking about plea negotiations, in order to develop an overall negotiation plan, counsel should be fully aware of and make sure the client is fully aware of the maximum term of imprisonment and fine of restitution that may be ordered and any mandatory punishment or sentencing guideline system. Well, that's obvious. What about number 3? Other consequences of conviction, such as deportation and civil disabilities. Again, collateral consequences. Not a new concept at all to the ethics of practicing law. Jose Padilla. Jose is an interesting guy. Jose was from the Honduras, and he lived in the United States for about 40 years, and at the time of his involvement in the case that went to the Supreme Court, He had been here 40 years and had served his country honorably in Vietnam. He was an immigrant. All the consequences of an immigrant, the emotional input of that. And anyway, Padilla is from Honduras. He was here for a long time. He served his country honorably in Vietnam. And then he watched too many Cheech and Chong movies and decided that he too would like to get an 18-wheeler and provide marijuana to those who were seeking it in Kentucky. Unfortunately, he got caught. And when he got caught, he got arrested, he got convicted, and he then found out he was going to be deported. A guy whose picture I have, I think, Matt Kriegel, was the attorney who represented the state of Kentucky. Matt actually worked in our office a few years back. His wife was going to medical school in Charleston and is a terrific lawyer. And when I talked to him about this case, he told me he was a little bit embarrassed having to defend the Kentucky Supreme Court, which I thought was a pretty bold statement for somebody who's licensed in Kentucky. But in any event, Padilla was convicted, and he brought a collateral attack on his conviction on the basis that his attorney did not tell him that he was subject to deportation upon conviction. That case eventually wound its way up to the Supreme Court, and the Supreme Court, in its decision, decided that yes, deportation is not imprisonment, it's not a fine, but it's such an integral part of the criminal process that it's incompetent not to advise your client of the consequences of deportation. Before deciding to plead guilty, the defendant is entitled to the effective assistance of competent counsel. Here we are again, the same language that arises from the ethics. Deportation as a consequence of a criminal conviction is because of its close connection to the criminal process. The court also said that the Solicitor General, arguing on behalf of the state of Kentucky, urged us to conclude that Strickland applies to Padilla's claim only to the extent that he has alleged affirmative misadvice. What does that mean? That goes back to the South Carolina case we were talking about, Judge Toll, that if you give advice, it has to be correct. So in the state cases, if you review them, the incompetence of counsel is only when the counsel speaks up. But ethically, how can you justify keeping your mouth shut and not fully advising your client is the proper thing to do? Again, in that decision, the Supreme Court looked at what's the prevailing norm. And the prevailing norm, as evidenced by the ABA standards and by the National Legal Aid Defenders Association standards, is that you should advise your client of collateral consequences.